welcome back to the stage here. We hope you're enjoying kind of a nice, relaxing lunch. As you heard during our previous panel, and even also the panel before that, protecting your technology can be an important part of really setting your business up for success. And you might be thinking right now, well, let me run out there and put together a patent application and get it submitted. But the world of patenting can be difficult to navigate. There are application requirements, forms to fill out, data and information to gather. It can be quite overwhelming, as you heard during a number of our panels today and from a number of our speakers. And many people will actually work with a licensed patent attorney to put together that application. But what kind of critical information do they actually need from you to move forward? What are some of the things you should have in hand to make, I would say, both of your lives, but really all of your lives easier? We're going to explore these points in our next talk here, which will be kind of a really quick fireside chat. I'm now going to welcome Paul Dittmeyer and David Park to the stage, and I'm going to help lead this discussion between these two luminaries, aka I'm going to try not to sound dumb while they provide you with some brilliance in these different areas. But I'd like to start us off kind of with our first talking point here and use that as a segue for Paul and David to introduce themselves. And let's start off with this talking point for both of you gentlemen. And David, I'll let you go first here. What is something that you think everybody should know about the patent process that probably will surprise them?
Okay, thanks, Del. Thanks, New Mexico State and the other organizers for having us. I really appreciate it. And I think this is such a great program for small businesses. Well, just as by way of quick introduction, I've worked in the private sector for law firms domestically, internationally for about 15 years, but I'm currently in a nonprofit university setting for the past 2.5 years. I'm a program manager at University of Alaska Center ICE, the Center for Innovation, Commercialization, and Entrepreneurship. And I'm also a USPTO representative for Alaska's Patent Trademark Resource Center, in which we reach out to the general Alaskan public, at least, to provide USPTO resources for patents and trademarks. But with regard to that question, I think one surprising factor could be cost. In terms of, it could be in terms of different people's perspective, but for the inventor, there's definitely a cost involved in terms of your time that you need to spend. Even with a working patent professional, and the cost in terms of capital too. It can get expensive to actually file a patent application, and then even to go through that process of communicating with the USPTO. And then once a patent is issued, even to maintain a patent, there's some cost involved. So I think that could be surprising to certain inventors. But that being said, I do think patents are a valuable business asset. And there are some ways to maybe lessen the cost through what's called provisional patent filings, and also to utilize some of the resources that the USPTO provides, even through a local patent trademark resource center. They can guide you to resources like pro bono services that may be available to you depending on your time frame for how quickly you want a patent application. But even though there is some cost involved, definitely would recommend working with a patent professional, just because of the large legal hurdles as well involved with a patent application.
Hey everyone, Paul Dittmeyer. Thanks, Del, for having me. I've been working in the patent field for 30 years now, originally as a patent examiner with the USPTO in the mid to late 90s. And then for a few law firms working with Fortune 500 to small companies. And then recently, the last couple years, I've been directing a practice where we focus on helping entrepreneurs and small inventors and startups, because as David mentioned, the cost is of filing and procuring a patent can be pretty high and shocking sometimes. So we try to make a sort of a more budget friendly approach. We collaborate with inventors a little more than a typical law firm will. You'll get a little homework, I guess, is the way to put it from us. So something I think that, anyone new to the patent field might be surprised at, and I agree with David, the cost, is a big one, but also the time, the length of time that it takes, the difficulty and sort of speed bumps, the way the patent and trademark office is set up is very unique. When I went there in the 90s, the training for an examiner, they train examiners to reject patents. They reject patent applications, and that's the main focus of their training. So when your application is filed, you shouldn't be surprised to get rejections and objections. That's just the way the patent office works. And then it's up to you and your patent attorney to figure out, why the examiner's wrong, and file arguments. Sometimes you have to make some amendments. And so these kind of speed bumps may be surprising to some inventors, but it will typically, a patent application, the pendency right now for a typical application is over 18 months before you even hear back from a patent examiner. So that can be surprising. And then the total pendency, with some back and forth, you could be looking at, over 2 years or more before you're actually holding a patent in your hand. So, but the good news is during that time, your patent is pending, and that's helpful. It kind of creates a mystery out there. The competitors can't really see what you're patenting, exactly what you're claiming. So that can be an advantage to actually, that length of time could be an advantage. But again, it is a little surprising how long it takes.
And I think that, both of you kind of hit on some good surprising elements. And this might be a chance to give a collaborative answer, or, each one of you can give an answer or speak towards this. But, we talked a lot throughout today about, different resources, different tools. What is one tool that you think everybody should kind of have in their back pocket when they're thinking about any sort of patenting or any sort of intellectual property protection?
Should I jump in? I just wanted to chime in on Paul's surprising factor about the timeliness. I do think that is very surprising to most inventors. But I know Paul and I have discussed before as well. There are some options to possibly speed up or accelerate examination. So those things are really good to be aware of as an inventor. You're looking at possibly 2 years of even for a first examination of the application at the PTO, depending on the technology and art unit. But there could be certain pathways to speed up examination. So I think, working with your patent attorney to talk about those, whether it might be based on age or requesting prioritized examination for other means, those are things to be aware of, at least for the new inventor. But then also, it does make me think that you really have to, once you know that it could be such a timely affair, you really want to know your goals for patenting in the first place. If your technology is really going to be that long term and you want protection for that long term. For example, like the biotech industry, they're definitely willing to invest and invest in a patent portfolio because they know that there are long-term benefits after the patent issues. But certain technologies, if it's really going to be changing right away, then maybe patent protection is not quite the best avenue for all the time and effort it might take to get a patent.
Yeah, and to follow up with that, I'll say, another issue or maybe surprising uh, aspect of it is that not all patents are created equal. So it's it's general. The public who's not familiar with it, you just hear, oh, this was patented, right? And you just think, oh, Amazon patented one click. But that's really oversimplifying, what's going on there. There's this whole section of a patent called the claims, and those are legal definitions of your inventions, and every word in there counts. And so, you could hold two different patent attorneys could file, applications on very similar technology and get patents, and one patent could be very valuable, and one, might be suitable for hanging on your wall in your office because it just really, that's the value of it. It's written too narrowly or whatever. So that's another surprising aspect. But to Dell's question about tools, I don't know if they're, maybe in a general sense, I just think having a strategy, in within your business or within your R&D team, having a strategy, having a weekly or a monthly meeting, and having notes, trying to hone in on, you know, what your team thinks is novel. What are the novel aspects of your technology, um, and just sort of keeping up with that. And then maybe on top of that, you know, brainstorming on, other ways. What are competitors going to do, maybe to try to do something differently. And if you can kind of get those all together, you can figure out what they share. What features are shared between all those solutions, and those are points that you want to emphasize to your patent attorney ultimately about what you think is novel, and that's how the patent attorney then is going to use that information when they're writing the claims, which again is a very critical part of the application.
If I could jump in, I think one aspect that inventors should be aware of, or small business owners, right? As a patent attorney, I want a lot of detail about your invention. So, in terms of a written form or figures, as a patent attorney, when I was practicing, um, I'd want a lot of details so that I could describe it well and put it into the description, the specification of a patent application. But also, what a good patent attorney will do in terms of the claims, as Paul mentioned, which are kind of the outer boundaries in the English language, trying to describe what the outer boundaries of your invention is. You can imagine that could be not an easy task, trying to describe um, an idea in a sense. Um, but a good patent attorney will have different levels of breadth and narrowness of claims. So the way I think about that is, your deed for your house or land would have um, real latitude, longitudinal description of your property. So the more property you have, you can think of that as a broader idea. So that could be more valuable. You'd have more land, and the more and more description you have, it could be a narrower and narrower piece of property, which could be less valuable, but you can get a patent for that probably. So, in my experience, I've had inventors come up to me with a patent in hand, but they would have like 2 full pages of claim language, which to me means that it's very, very narrow and probably less and less valuable the more pages you fill up with the claim language. So, um, as a patent attorney, I do want a lot of description from my inventors so that it will help me to draft with the inventor a patent application. But in terms of the claims, you want to be really careful and make sure that you get as broad a claim as possible in light of the prior art, what's been done before, so that you can get more value for a patent.
Yeah, that's a good point, David. I agree 100%. With my inventors and clients, I always say, we're going to describe more and we're going to claim less. But you have to have that description there so that you can enable and you can have language to claim, right? So all that you want to describe multiple variations, any type of alternative features or embodiments. Even if you don't think that's where your business is ultimately going, if you think a certain feature or part of your invention could, be A, B, and C, then we need to include that in the description. The patent attorney and you can then discuss whether that needs to be in the claim that specifically, right? So David's exactly right. Um, very long claims appear narrow, and there's a certain time and a place where you need a really long claim. It could be that the tech field is very crowded, and maybe your invention for a new smartphone is, it needs some very narrow claim languages because of how much prior art, as we call it, is out there. So um, yeah, it's a good point. But yeah, that's why I say describe more, claim less. That's our goal.
And I think this is actually a point that both of y'all can speak towards. We had a kind of question that came in, and somebody was wondering, from each of your perspectives, do you think it's important to keep up with competitors and know like what they're doing, what's going on, kind of how you can claim different things than they are? Or should people really focus more on their own technology first and putting together a strategy around that?
Well, I would say the answer is probably both. You primarily, I think you focus on your tech, especially for a startup or an entrepreneur. Some some bigger clients that I've had, they're intimately knowledgeable about everything going on in their field. And they don't even order patentability search opinions anymore because they're one of the main innovators and they're in this space and they have a patent portfolio, and that's great, but that's not usually the case for startups and entrepreneurs, right? You're probably just getting into this for the first time, and it's good to know what your competitors are doing, of course, right? And many of you probably already do, right? If you're innovating in a space, you're probably aware of what the next closest technology is. You're not going to know everything, and a patentability opinion is certainly not going to find everything. It's just not possible, because it's novelty throughout the world, so that's a difficult task. But I think a little bit of both. But for startups and entrepreneurs, I think focusing on your tech and what you believe you know is novel, and the novel aspects of what you're trying to get after, I think is probably primarily the focus.
I'd agree with that, but also I do think that it's helpful to uh, do your best to know what's out there in terms of prior art or what's been done before, uh, technology that's been published, um, because you don't want to waste your money in a sense or time trying to patent something that's already been done, right? Um, or investing a lot of effort um, towards something that won't be allowable. So that kind of awareness um, is always helpful. I know some patent attorneys never do a search before drafting a patent application. They just want to draft based upon the disclosures that's given to them by the inventor. But I'm on the other side of that, where I do want to do searching to see what's at least initially available as a publication. just so that I'm more aware and the inventors could be aware too of what's been done before. And then we can see if certain aspects of what the inventor is doing might be novel or new over that prior art. So I'm also, of course, we need to focus on your invention and technology, but it's definitely helpful, I think, to be alert to what's been done before. And also, you can learn from what your competitors are doing. One of the philosophies of the patent system is to publicly disclose to enable one of ordinary skill in the art to practice what's the invention. So it's really kind of a quid pro quo system to give to society the invention, but the inventor has kind of a monopoly for a limited time, like 20 years from the application filing date. So you can actually learn from the patent system about different technologies and how to improve upon that as well, because a lot of times patents are for improvements, not such ground breaking technologies.
Yeah, I agree with that. Yeah, and it helps your patent attorney to write the claims more accurately.
Hmm.
When when you first file a set of claims with the application, they're going to be examined, and the more accurate you can have those claims in terms of novelty is the main one, as a hurdle at the patent office, is going to be helpful. So the more you know about the prior technology and what already exists, the more accurately you can write those claims. Certainly, yeah.
There's one point that I would like to dive into a little bit more, and it's something that, you just brought up, David, and it's also something that Molly pointed towards in the keynote. And it is really about that knowing what you want to get out of a patent and knowing kind of why you're doing it. And wonder if each of y'all could just kind of talk to the point about, in your perspectives, why is patenting important for, business kind of growth and success? And why, what is like a hallmark where somebody goes, I should really start to figure this out?
Do you want to start, Paul?
Sure. There's the full spectrum of why patents are valuable. A single patent to an entrepreneur or startup, you know, can be extremely valuable for different reasons. It could be valuable in terms of valuation if you're looking for investment, um, and it could be valuable in building or you know preventing competition, or at least keeping the competition away, having a superior product. And we talked about claims being very narrow. So an example would be, let's say we had to get very narrow claims. There's still value to that patent because a competitor can't just take your tech, buy one of your products, ship it overseas, and have it exactly copied and brought back into the U.S. Even if you have a very narrow claim, you can still prevent that from happening, right? And there still could be value in that because that could really affect your profit margins and affect the market share and things like that. So um, there's different reasons. Bigger companies that I've worked for, they would file, they would say, from somewhere up on high, it would come down and would say, we need 40 or 50 more patents, this quarter, you know, or they're forecasting for, 2 years from now. And that's mainly to drive up stock price. It's to, scare competitors. It's to be a player in that space, having a large patent portfolio, especially if there's, let's say in telecom, especially mobile communications, there's patent suits pending all the time, and they're always negotiating and cross licensing. And if you don't have a big patent portfolio, you're not a player. So there's various reasons. They certainly differ between, whether you're a big established company and whether you're an entrepreneur and a startup. And so there's value across the board, I think.
Yes, I mean, as a patent attorney, maybe I'm biased, but I mean, large companies with large budgets, patent budgets, they set aside yearly budgets for developing their patent portfolios, and they can use it offensively and defensively to sue other companies. And when they're being sued, they can use it in a defensive sense. Um, but I think from a small business perspective, it could serve several purposes, as Paul mentioned. I mean, if you think that there's real value in your technology and you can commercialize it, then the only real way to protect that technology from being stolen is to file for patent protection. I mean, there's other intellectual property aspects too. Maybe you can try to keep different parts of it as a trade secret, but many times, if it's really publicly available technology, you'd want to try to seek patent protection so that it can't be stolen. I know a lot of small business owners worry that, yeah, if I disclose this, isn't this going to be stolen from me? Well, unfortunately, that could be the case if you publicly disclose without a patent application. And it kind of places a mark in time where you're saying, this is my technology, and what I've described, you should not take it from me, because I'm the inventor. And in that case, in the United States now, it's a first to file system as well for the patent system. We're following the rest of the world in that sense. So really, to get something on file as a description, as an enabling description of your technology, it is very important to protect from being stolen. But I can think of other things where really maybe you're seeking more funding, and having a patent application in place does seem like a tangible, much more of a tangible business asset. Even saying patent pending, something like that, which you can say when you file a patent application. It could be valuable in a business sense. So, and also if you need to do more research to further develop the technology, having something on file can be very valuable from a business perspective, from a protection perspective. So yeah, very valuable asset to have for various reasons.
Yeah, and I don't watch the television show, but some friends have told me, like, even on this show Shark Tank, some of these sharks will ask these entrepreneurs a simple question about patents, and immediately that can increase or decrease their valuation. So it's a real world example, although Hollywood produced, but still a real world example of how just the patent pending or filing for a patent can create the appearance that your valuation is higher, and it really works. So.
Well, I think that was some really excellent information to kind of bandy about here, and really just to get, again, people heard me say it last panel, they've heard me say it a couple of times throughout both of the days, is we want you to walk away from this event with a healthy curiosity, being able to know that there's something out there, that there are these, abilities, that there are these different ways you can approach it. Nothing is ever going to be form, fit, function, do this. This is the only way to do it. This is the only way to succeed. Things are going to be unique. So I would say that if you have questions that we didn't get a chance to address, that we didn't get a chance to respond to, please message David and Paul in the platform. See if you can connect with them. See if you can have a meeting with them. There is a bunch of information out there, and we would like to just try and connect you to it. Paul and David, I'd also welcome the chance if you'd like to drop your email addresses into the chat. I'll make sure that people get them, just in case you're open for people, sending you a quick email and saying, hey, is there something I can discuss with you here? Can we actually have an opportunity to talk?
Sure, I will drop my email right now.
Alrighty. And while they're doing that, we're going to transition to our next kind of scene here, folks. But really, thank you, Paul and David, for that smorgasbord of information and knowledge on some of the things that people want to know about properly working with patent attorneys, and at the end of the day, making everybody's lives just a little bit easier. Now, we are going to kind of let you enjoy the remaining 15 minutes of the lunch break. I'm going to put on some more smooth music, and then we invite you again, head out to those booths, talk to some of these organizations, whether it is the panelists that you heard from last panel, whether it's connecting with one of the federal agencies being represented today, like the Navy, NIH, USDA, National Science Foundation, Department of Energy. There is a lot of knowledge out there that you can tap into. There are a lot of resources you can tap into. And at the end of the day, guys, it's about you tapping into it. Take that step, take that first step, get that information, make that connection, and start to build your relationship matrix, your network, and that Rolodex of people that can provide you assistance and that can help you. But again, take the next remaining 15 minutes, finish up your lunch, have some more caffeine, which I'm going to go do right now, and we will welcome you back at roughly 2:40 for our last panel of the day.